Welcome to another installment of the Primerio Africa Enforcement Session podcast. We are here with our colleague Monalisa Mushobozi from Mwebesa Law Group in Tanzania. And we have as our esteemed guest on the podcast today, Zaytun Kikula, who's a senior enforcement official with the FCC, the Tanzanian Antitrust regulator. Monalisa, my colleague, is going to introduce Ms. Kikula shortly. I just want to wish everybody an informative session. And again, Primerio Law is hosting this together with Mwebesa Law Group in Tanzania, our partners. Monalisa, take it from here.
Thank you, Andreas, and good afternoon, everyone. I am Monalisa Mushobozi, as introduced by Andreas, from Mwebesa Law Group. It's a firm, full-service law firm based in Tanzania, with a focus in, amongst many other areas, antitrust as well, and competition law. We have worked with Primerio on various issues. And in this podcast as well, we have Zaytun Kikula, who is the Director of Research, Mergers and Advocacy at the Fair Competition Commission. Ms. Kikula has over 15 years of experience working in competition law and antitrust. So she's well versed with consumer protection, mergers and acquisition, and any other sector regarding the competition law. So she's here to address some regional and Tanzanian competition law issues. Thank you. So to proceed, Ms. Kikula, just briefly, would like to hear from you so far. First, what is the current setting of and priorities of the Fair Competition Commission in this current regime 2025? What areas of priorities do you guys have, and what major issues have you guys encountered when it comes to mergers, acquisition, and the likes?
Okay, thank you very much. Good afternoon, everybody. Yes, currently the Fair Competition Commission has been concentrating on the issues of mergers mainly, but at the same time we are looking on the issue of investigation, particularly on dominance, abuse of dominance, and cartel. But our main act has been more on the major issues. We've been very active on the major section. We've been reviewing a lot of major. Roughly, I could say in a year we dealt with around 50 to 70 majors altogether, the smaller ones and the bigger ones, but by far we mainly received the smaller ones, but really it kind of give us a kickstart in enhancing our capacity in dealing with majors. We kind of few number of the bigger ones, but mainly we dealt with across the sectors. I could say from the telecommunication, finance, manufacturing, mining. So that's the main insurance. That's the main area that we've been dealing with. Yeah.
Okay, thank you. And speaking of mergers, most recently the amendments to the Fair Competition Act 2024. So I would like to know, how has that in practice impacted the applications brought, the environment? How has the market responded to that? And how do you see it as, are applications increasing or decreasing after the amendments?
Oh, yeah, actually, when we look at the amendment, it hasn't been long because the amendment just passed last year, October. So yeah. It hasn't been really that long, but the quick review, the amendment, they kind of shifted the way that the normal way that, or the previous way that we've been dealing with the major notification. And now it's kind of, it's more clear to most of the supporting stakeholders, which are mostly the legal firms, the legal regime. They've been really like bringing a lot of transaction that now they understand clearly the parameters that we are looking at, because before this amendment, the focus was the major should not strengthen or create the position of dominance. But now the assessment shift to to assess the major that to ensure that the major are not lessening competition. So we look into all the parameters of, let's say, coordinated effects, unilateral effect, barrier to interest. Those are the things that we are looking at, plus the market share. But because before this, the focus area was only the market share, but now we expand the horizon of our assessing the major. So we found that we've been receiving quite a number of majors now, since the general public started understanding as to why we are assessing the majors. Because before, people, they were just looking on the market share only, because that's how the old law was crafted. But now it's more, we expand the boundaries of how we assess it. So I found it's more like the general public understands more, and they see the importance of coming in, and for them for the transaction to be assessed. So I could say the amendment kind of shift the normal way that we've been dealing with the majors. Now it's more involving.
And one among the changes introduced by the Act was that a merger may be approved even if it strengthens a dominant company, but if it has a public effect, a good public effect interest. In practice, yes, has any such kind of merger been brought up front, and how has the fair competition dealt with in approving it? What are the conditions, if any?
So far, we haven't received any transaction that really hit the or trigger the test of that particular section. But we've trying to look, even if we assess the normal ones, we try to see if there's any public interest into it, so that to enhance the decision of the commission when they determine on that. But so far we haven't really received any one particular falls under that particular section.
Okay, thank you. Another question on the same note. Other jurisdictions, when you mention public interest, have a tendency of, when a merger is filed, to ask for the opinion of the public. I take note that you guys take into account public interest, but is that something that Commission does as well, take into consideration people's outcry or opinions when making a decision and approving, or how do you go about it when taking into account public interest?
Yes, actually, in our system, all transactions that have been notified, we have to call for public opinion. If you remember, we have like 14 days. Once we receive a notification, we issue a public notice to the public. It runs for 14 days just to receive any public concerns. So even in that particular transaction, if we receive, that's the route that we'll take. We'll call for public opinion to see if there's anything that Commission need to receive from the public to enhance their decision, in particular in the focus of public interest.
Okay, thank you. And so far, what actions has the Commission taken once a merger has been conducted without notification? I know there are penalties and sanctions. In practice, have you faced, as of recent, any such mergers, and what has the Commission done about it? Do you reverse the merger outside the penalty, or?
Yes, we have quite a number of applications that have been the merging firm, they proceed without notifying to the Commission. So once we receive, some of them they come up from themselves, and some of them we find them through investigation, because we normally do investigation. We have an investigation department and the research department. So some of them we found them under those areas. But what we do, we engage them and to let them know that they proceed without notifying to the Commission. It's an offense, as the law says, and the penalty is 5 to 10% annual turnover. So once we engage them, because we are the business facilitator. I know it's a wrongdoing, but since we are the business facilitator, and we all know that once the merger have been proceeding, it's very difficult to tell them to undo it and go back to their original position. So what we do, normally we engage them, and majority they agree to settle. So what they do, they pay the filing fee as if they were supposed to file at that particular time, and then on top of that, we discuss the settlement fee as a penalty on the conduct that they commit. That's how we've been going about.
Oh, thank you. You've mentioned filing fees. I do have a follow-up question on that. When assessing filing fees, of course, the Commission looks at the turnover of an entity. So the question is, do you look at the global turnover or the domestic turnover of an entity? For instance, if an acquiring company is a parent company, but it has presence in Tanzania, and so do you look at the turnover of its market share in Tanzania, or do you look at the global turnover of the acquiring company?
How it is that once what we look at it is a formation of that particular transaction. If the transaction involves the global, then because as you know, the transaction has to have the target and the acquirer. So it depends. If the acquirer is the global, then we look at the parent company, the global turnover. If the acquirer is only the local nexus that existing in Tanzania, we have to look to the existing company in Tanzania. So it depends on how the formation of that particular transaction. If it involves the global, then we look at the global. But if it involves only the Tanzanian company, then we look at the company. Because some of the company, they can be global, but they don't have on the financials, they cut. They have the particular financial accounts for the local nexus, and they have the global one. So the global one, it's only reporting the local nexus. It's only reporting to the global on their arrangement of reporting, but they are not. The global does not influence the finance of the local nexus. So it depends on how they crafted the transaction is being crafted. So we can either, sometimes we look at the global and sometimes we look only at the local nexus.
Okay, and in an event, because it has happened before that the transaction, the financials do not have the specific segment for the local nexus. Is there room for conversation or dialogue with FCC on how to go about the filing fees, or is it just as stipulated by the law, regardless?
No, it's just as stipulated by the law, regardless, because what we look, as much as for Tanzania, the notification is mandatory, but they are merging firm are the one who are assessing what are the financials, the accounts, how do they crafted the accounts, so are the one who submitting those. So if they assess themselves with the global, then there's no way we can find how the Tanzanian company's financial position is. So it depends, as I say, depending on how they crafted it. And if it involves the global, then we have to look at the global. So on terms of to negotiate on how to pay the filing fee, unfortunately, we don't have that provision. Yeah.
Thank you. And ideally, how long does it take the Commission to approve a merger? I know that the law says it's 60 days, but there's some cases that it's been before, it's taken shorter or longer. But in practice, with your experience and you know what is involved internally, how long should someone prepare beforehand mentally that this is the amount of time it's going to take for a non-complex one and for a complex one?
Okay, for a non-complex one, it can go to 30 to 45 days. It should be cleared because the Commission sits once in a month to determine on the matter of merger. For the complex one, it depends. Sometimes it can go to 90 days, sometimes it can go to above 90 days because the total number of reviewing merger by law is 135 days. So it depends because as you understand, we have to consult different stakeholders. So it depends with the nature of the transaction in sector it involved in. So if we manage to get all the information as soon as possible, yes, it can be as fast as it is. But normally, as I said, the non-complex one is only it's around 30 days to 45 days should be cleared. And the mid-range can go to up to 75 days, and the very few one that goes to over 90 days or even to 135 days sometimes. But those are very few ones. Yeah.
Okay. And for the complex one, usually if you do get to approve, and I understand sometimes with conditions, what are the most common conditions that the FCC imposes on these mergers?
Again, it depends with the sector because some sectors, like on the manufacturers, we have to see if the major involved taking off the factory of that particular target in that particular sector. Also, among the condition could be make sure that factory is not dying. So it should continue processing or producing. If it's in agriculture, again, we have to look at the agriculture formation of that particular sector. If it involves small growers, we have to put a condition to make sure that the acquiring firm should make sure that it continues buying from the local producers of that nearby that particular either factory or main farm. So those are the conditions, and sometimes other condition could be. In this one, we take as a reminder for merging firm, they have to comply with other laws, because sometimes, let's say the acquisition or the merger involve acquiring of the assets or land. So we are not dealing with the land laws particular for the country. So we have to remind them this particular approval, it's only for competition matters. So in case you need to comply with other laws and regulation, please make sure you abide to it and comply with it. And they normally do undertake. And once they comply and complete that process, they just notify the commission that we comply with this and this is the situation. Yeah, that's what we do.
I suppose just related to that point, has there been any experience of structural remedies imposed by the Commission in recent cases?
We tried, I could say, into 2 measures to put the structural remedy, but it didn't reach to the fullest of it, because the merging firm, they really kind of come back to the commission and plead to restructure the transaction so that structural remedy didn't happen. But if I remember well, we had only 2 transactions that really get to that. We request for diversification, and the other one, it was removal of director from because they had a director who's sitting in both. Those are the ones, but mostly it's a behavior. That's the condition that normally we impose. Yeah,
that's helpful.
Yeah. I think I'm gonna wrap up with just 2 last questions. First, from your experience, I'm seeing many investors coming in Tanzania, foreign investors. How is that translated when it comes to mergers and acquisitions? Is there an influx of it from foreign entities acquiring local entities? And how do you or what do you advise? Because those people are coming with their local foreign counsel, basically. So practitioners advising people to acquire firms in Tanzania. What practical guidance would you give to them?
Like I could say, the quick 4 ones. One, engage FCC as soon as possible, just for clarification, because sometimes when they come in, they're not sure if this is notifiable, what. So they can pay a visit, not necessary to write. They can pay a visit and just to get the clarification and what parameter they're supposed to notify. And if they're supposed to notify, they have to be clear. They notify on time, because sometimes we get a challenge. They come in for discussion. You inform them, after discussion, they agree that they're supposed to notify. And they wait until their very last few days before they concluded the agreement. That's when they want to finalize every procedure. So as I said, there's a procedure to follow. And sometimes there's like 30 to 45 days or 30 to 90 something days. So if you didn't give us enough time, and because as you all understand, analyzing major, you need to get information from various stakeholders, and sometimes some of the information that we are looking at, they're not in our hands, so we have to consult other stakeholders, and they have their procedures, and sometimes it takes a bit of time. So as I said, they could invite, as advised, they should involve FCC as soon as possible or at the earliest stage, and get cleared how on their timeline. If they have anything that they feel like need to be taken as soon as possible, as to be decided as quick as possible, they should inform the commission at the notifying stage or the very early stage, so the commission, they can see how they can align, because saying that if we get those kind of transaction, when we request the information as well, we put like a note to those that we are requesting information, kindly assist us to get this information before on this particular date, because this particular client have the deadline of this date, so kindly assist. As I said, because we are business facilitator, so whenever that we can assist and to make sure things are flowing as fast as possible, that is our intention. So those are the main two, I could say. Yeah.
Thank you, Ms. Kikula. That is it from my end. Over to you, Andreas.
Thank you, Monalisa. As I mentioned briefly at the during the introductory part of this session, I represent Primerio. I'm a partner with the firm. The firm is a little over a decade old. We are a regulatory Pan-African firm with a focus on competition law, antitrust matters, as well as white collar and other business law matters. We've had business before your organization, Ms. Kikula, the FCC. By the way, I love the name, Fair Competition Commission. I think it's great that the FCC has the adjective fair in there. Not a lot of entities like yours, regulatory bodies, have that. They just call themselves Competition Commission or Antitrust Authority. I think it indicates well the purpose that you are trying to have a level playing field, and that you are, as you just called it very poignantly, business facilitators for the Tanzanian market. So yes, we recently had a matter before you, and it went very smoothly. So I can attest to that. Other than maybe the filing fee, I remember we had a slight issue with the payment there. So I think that may need to be smoothed out the process, but that's more of a banking issue than a substantive issue. I would like to first thank you for being with us today and taking the time. It's an honor to have you. And I would like to cover the regional element that is becoming more and more prevalent across the African continent. As I think a lot of our listeners will have also learned by now, there's not just the domestic national competition authorities, the NCAs, such as yours, but there are the regional ones like the COMESA Competition Commission. ECOWAS now has its own competition commission, the IRCA, and the EAC has the EACCA, which is coming online November of this year, accepting merger notifications, for example. And there are others. The AFCFTA comes to mind, which will probably be operationalized soon as well. So I wanted to transition into that area, if I may, and ask you first and foremost, which ones of those entities are of most relevance to parties that appear before you? I assume it would be the EACCA, the EAC, correct? Because you're not a member of, Tanzania is not a member of COMESA. It is, however, a founding member of the EAC, one of the three founding nations, Uganda, Kenya, and Tanzania. So
yes,
I guess it dates back a quarter of a century now. What other regional bodies do you interact with besides the EAC in terms of your capacity as an antitrust enforcer?
We are a member of the SADC, but SADC hasn't really started the competition practices. They are on the verge of creating the law and things like that. So though we do exchange information and have some engagement with the SADC on that area, and then now there's a coming of AFTA, African Free Continental. So that one as well, we are fully engaging in that one. Now we are in the negotiation of competition rules. The competition protocol has already been assented. Now we are moving to the competition rules. So that's another block that will be engaging fully on it beside the EAC. Yeah.
Right. Focusing on the EAC then, because that's obviously the most relevant regional authority to those doing business in Tanzania. Does the FCC, and specifically you and the merger shop, your team, do you recognize the EAC as a one-stop shop, a la the COMESA Competition Commission, a la European Commission, as a matter of principle?
I won't say we are recognizing it as a one-stop center for major notification, but as if you happen to see the EAC law in terms of major notification, they terms that once the transaction meet the threshold that they've been set at, which is around 35 USD million, it should be notified to the East African Competition Authority. So, with that regard, I would take as EACs as a referral block. But since they haven't really started, we believe that once they kick off in November, they'll give us parameters on how to engage with them. That's what we are all looking forward. Right now, all the transactions that have been notified in each state, member state. So once we have a transaction that are a cross-border transaction and need to be notified to the competition authority in East Africa, then I believe they'll give more clearance on how to go about. Yeah. So we notify as upper body from the member state, but really we haven't really agreed to call it a one-stop center.
Okay. So there could be, in theory, I guess it remains to be seen, as you rightly point out, starting in November of 2025, but there is a conceivable scenario where, as in the early days of COMESA in 2013, 2014, for example, where there were individual COMESA member states, such as Kenya, that would challenge the parties and say to the parties that, no, you cannot just file with the regional body. You must also file with our domestic body, even though that is technically in contravention of the COMESA Treaty and the competition regulations, and in principle would also go against the concept of the one-stop shop merger filing system of the EAC. But if I hear you right, just to be clear, you're saying it obviously it has not been tested yet. That's duly noted and understood. But you're anticipating that there will not have to be dual notifications, and instead you will have an understanding with the EAC, EACCA, that there will be either an EAC filing or an FCC filing.
Yeah, we tend to believe so because, as I said, if we go back to the Act itself, they mention or they include the issue of referrals. So what we tend to look at it is if the transaction reached it's a cross-border transaction and reached the threshold that under the EAC parameters, then that notification has to be notified to the EAC Competition Authority. And then if the EAC is during their assessment, if they found that that particular one particular member state, let's say Tanzania, has been affected more with that particular transaction, maybe they refer it back to the Tanzania, and then that's when the FCC, they can work on it, or they can work together with the EAC to make sure that the analysis of that particular transaction bring more. It's more beneficial to the company, to the country that is being affected more with that particular transaction. That's what we're looking at it. But to be notified into two places, that to notify in the block and then to come back to the member state, it's something really I don't think that most of the member state of the EAC will appreciate that, because that again it will be confusion to the investors, and it might bring a lot of head in collusion on the decision, because I'm trying to see if, let's say Tanzania, we approve it, and then the East Africa, they approve with the condition, then where do that particular firm where should they follow, the member state or the bloc? So I think that's why I say we're just waiting to hear from the East Africa guidelines. What would they say those particular transaction and how we can go about. I think once we engage and agree way forward, I think we'll be more clear on that. But now to look at it, I think we'll try to avoid in both ends, the East Africa, even the member state will try to avoid those double notification, because if you notify in both places, the chances in some transaction you can have different determination and might bring some confusion. So that's why I say that.
Similarly,
That is,
we've noted that the COMESA and the ACCA have overlapping member states as well. We understand that is going to be addressed by the relevant regional authorities in a meeting up and coming soonish. But having to have almost triple notifications with the same authorities and same member states will be interesting to see how that develops in practice.
Yeah. So yeah, as you said, so some of them they'll be in 3 blocks. So how are you going to notify? You have to notify in Tanzania. Let's say if you're a member of COMESA, then to EAC, then to COMESA. So I found that will be a bit of a burden to the investors. So I think once that started, we'll find a common way how to deal with it. Yeah.
that is a heartening thing to hear, certainly for our client base who may be listening to this podcast, because in our experience as outside counsel on these regulatory matters, we've certainly had the opposite experience from what you just said, Ms. Kikula, which is where, for example, in West Africa, right, where ECOWAS and Nigeria are fighting, the FCCPC are fighting over jurisdiction, or again, back in the day, about a decade ago, where countries such as the Kenyan CAK authority and the COMESA Competition Commission were fighting over the jurisdictional authority. So it is heartening to hear from your side that you, as the FCC, speaking on its behalf, will be trying to avoid that entirely and ceding authority where there is a regional dimension to the EAC, and taking authority and perhaps having a referral back from the EACCA, where even though technically the thresholds may be met by the bloc economy, that it will still be referred back to you because perhaps it's a national champion type entity that's the acquirer or the target or the like. So that's heartening to hear. In terms of information exchange, you said you are still figuring things out with the EACCA regarding specific transactional rules and pragmatic elements of the merger regimes. But in terms of the information exchanges and confidentiality claims of the parties to their materials, which are often quite important to their businesses, especially given that you termed yourself a business facilitator at the FCC. What is in place so far, or what are you envisioning for those protections to business confidential data and other materials?
In both acts, the East African Competition Act, even the Fair Competition Act, there is a provision that it's mandated for confidentiality of information that we receive. So I believe once we start working on major from both ends, that is one of the provisions that is really need to be abide to. That's one. But even now, we haven't really exchanged information particular on major, but we do have exchanged some other information, maybe on a research basis, in some awareness basis, or preparation of some documentation of East Africa. We get involved. We have that. We have the MOU, and one of the provision that MOU is confidentiality and protect the merging firm or any other information that we exchange in confidential. So we have that, and we really are keen to that. Yeah.
And just to be clear, the memorandum of understanding you're referring to is one between you and which authority, the EACCA or others?
With the EACA, with the EACA.
The ACCA. Got it. EACA, right. In terms of the COMESA competition commission, are you, to the extent you can talk about this, have you had information exchanges there? Because again, as my colleague Tyla just pointed out, there are, of course, very heavy overlaps jurisdictionally between the COMESA member states, the EAC, and Tanzania is bordered pretty much all around by COMESA members. So it's a little bit of an outlier in not being a member of that regional trading bloc. So are you routinely exchanging data on perhaps investigations or merger matters with Dr. Mwemba and his team at the CCC, or is that a rare occurrence, or does it never occur?
With COMESA, not directly. We do meet under the the ACF, African Competition Forum. That's where we do meet, and through that forum, we do exchange, but under that particular forum. But direct from the FCC to COMESA, not that directly, but through ACF, yes, because we have groups for major groups to discuss different matters of major. We have groups for cartel. We have group for anti-monopoly. So we exchange information in that particular forum under the ACF, but directly to COMESA in Tanzania, no, we don't have.
Yeah, that's interesting to hear from you, especially since we've written about this actually on our blog on africanantitrust.com, that the ACF is one of those little known sort of outside of a very small insider group of competition lawyers in Africa. It's a fairly unknown entity as a grouping, but it's quite crucial in the exchange of very informative and important data points for investigations on the continent regarding cartels, market studies, investigations, etc. Not just between Eastern African nations, but really continent-wide, as you just confirmed. So thank you for that. Can you envision a situation where you have, again, focusing on mergers, which is your portfolio? Can you envision a situation come November, let's say realistically come 2026, and the EACA is operational, the competition authority of the EAC, where you would have a joint investigation regarding a transaction, even though it is only technically notified to one, as you pointed out earlier? You want to avoid dual tracking the notification process, also in the interest of the investing parties. But can you still imagine under the MOU having an investigation where data is shared and opinions are rendered by both FCC and the EAC authority?
Yes, I could believe so, that because if the transaction, it's a cross-border transaction notified in East Africa, but it has it's going to impact Tanzania. I think we have a room to run some investigation to inform the East Africa before they make the decision on it. So I could see that we should have a hand on it, just to assist the East Africa when they make in their analysis. They should know the part of Tanzania as well. So I could see that one. It can be done.
Right.
And just to add on, I think it's one of the areas that were, I think East Africa, they will have to consider and see how they can set up how to engage member states during that once they start receiving major notifications. Yeah.
To be clear, if my understanding is correct, the EAC authority will be staffed, or is currently already being staffed, but will certainly be staffed going forward as it grows. Similar to, again, I draw the comparison to the COMESA Competition Commission. It will be staffed from members, by members of the different member states, i.e. there will be Tanzanian competition experts, whether they're economists or lawyers or non-lawyers, that will form part of the staff of the EACCA, correct?
Yeah. Yes. Yes.
So is there, to your knowledge, is there a system in place for staff exchanges or trainings or anything of that sort where, again, similar to the CCC, which has some sort of exchange program, sort of a secondment where NCAs, National Competition Authorities, both send and receive members from the CCC. Do you know whether that is in the works as well, to have exchanges between EAC and the Tanzanian regulator?
I'm not aware of the exchange, but what I know, what the East African Competition Authority, they do whenever they have something they want to engage a member state, they invited us. Maybe they set like a working session or training, because we even exchange some just training. They invited the consultants, the facilitators, so they invited the member state from different member states to join their staff. So exchanging, I'm not quite sure on that one, but collaboration, yes, we've done that.
I think that qualifies what I had in mind. I'm using the term exchange program somewhat loosely here, but that's very interesting. And again, to our listeners, all of this comes with a caveat that it is forward-looking, and EAC is only coming online in a few months. So we're still, you included, looking a little bit at a crystal ball here, quite appropriate in this room, looking at the future and guessing a little bit, but we have educated guesses, at least in the room. I think that's it, what I wanted to cover regarding the regional elements. Tyla, my colleague in Johannesburg, do you want to add anything while we have Ms. Kikula here, and
no, I think
while she's imparting her knowledge?
That covers all the kind of regulatory questions, and Monalisa did a good job in covering all the national questions as well. So nothing more from my side.
Very well. Monalisa, do you have any follow-ups that are burning on the mind?
Nothing. I think that pretty much covered it, unless Ms. Kikula, if there's something specific you would like to speak about, either educate our listeners or some area of interest upcoming that we're yet to know, something the FCC has in works.
Okay. Thank you very much. Thank you for having me. As I said, we are now working on amendment of the rules and regulation, and we introduce two sets of regulation. We didn't have a lenience program regulation. Now, after this amendment of the law, now we are working on the lenience program. So once it's been completed, we'll announce, and it should be introduced to the public. And then we have a specific regulation for dominance, how to assess dominance, and how we set the offenses. So that one as well will come into place very soon. So those are the two additional regulation beside the amendment of the law. And as I said, now the threshold for market share, now it moved from 35 to 40 now. So when you assess a market share, the limit is 40. And then again, even in the review of major now, before we are concentrating on listening to the competition, focus on the market share. Now we tested other parameters, coordinated unilateral barrier to entry. So now we kind of expand our horizon on how to assess major notification. So those are the few areas that I wanted to highlight. But as I believe we'll continue to engage, and once the rules are out, we'll keep sharing and do more of the awareness so the general public could understand it. Yeah.
We would love to have you back on again, maybe middle of next year, once the new regs are out, which will coincide somewhat with the new COMESA regulations as well, which cover, interestingly, perhaps not ironically, but quite fittingly, the same areas, leniency, presumptions of dominance, etc. Right? So they're being finalized and voted on and will pass, in our view, at the end of this year. So you will be right on track with the CCC next door. So perhaps we can have a multi-enforcer session, which would be very enjoyable, I think, to have you and Dr. Mwemba or someone else from the CCC and the four of us. So it's been a pleasure from my end to be with you, to meet you virtually, Ms. Kikula, and on behalf of our listeners and our firm, Primerio, and Mwebesa Law Group, I want to thank you for taking the time today.
Thank you for having me. Thank you very much.
Thank you, Ms. Kikula, for your time, your afternoon, and it was a very insightful session, as Andreas said. We'd love to have you next year, mid-next year, or whenever there's a recent development as well. We'd love to have your presence on board. Thank you, Andreas, as well, for having us co-host this session with you. It was very helpful for us and our viewers as well. And Tyla, thank you.
Thank you very much for having me.
Thank you.
Bye-bye.
Bye-bye.